Hamilton. I am Executive Director of ASISTA Immigration Assistance. And with me today, I have Cecilia Friedman-Levin, who is our Senior Policy Counsel.
Hello, everyone.
This is really the first webinar under our new grant, and we wanted to just introduce, especially to those of you who may be new to our resources, what we are here to do for you and give you some examples of the kind of help that we can provide. Let's do the next slide, please. Do I do the slides, Patricia? Oh, there we are. So we're hoping that after this training, minimally, you'll be able to describe the kind of work that we can do for you, hopefully identify some specific ways that we can help you with the immigrant survivors that you encounter, and also learn what kind of issues are affecting your work with immigrant survivors, identify some of the issues that you may not be aware of that we can help you with. So it's a little hard with this platform to raise your hands, but it would be helpful to us to have some idea of who's in the audience. So how many of you, and Patricia, maybe you can help me tell them how to respond. Those of you who are attorneys, should we have them just put something in the chat, or is there a way they can raise their hands? Or
yeah, so people have the option to raise their hand. On the top of your screens, there should be a hand icon, a person raising their hand, and you can set your status that way. And I can go ahead and count how many people have raised their hand.
Okay, so let me tell you what the options are going to be first. It's going to be lawyers, domestic violence or sexual assault advocates, and a third category, which some of you may or may not be familiar with, is Board of Immigration Appeals accredited representative. So, and we can do another also. So how many of you are attorneys? Look at this. Okay, lots of attorneys. Okay, how many of you are domestic violence or sexual assault advocates primarily? And do we have any BIA accredited reps on the call? Oh, cool. Anyone who fits an other category that's none of those three things? Okay, well, and maybe Alejandra, as we talk, or those of you who fit the other category, you can explain how what we do for you can be helpful, and we're going to cover all the varieties of things that we do, because we do work with all of those categories, and the other category that we do work with is law enforcement and judges primarily, as well as people from state and local government sometimes. Okay, so you said I can move this by pressing that. There we go. So Cecilia, you want to give some background on who we are and what we provide?
Right, and thank you. And before we do that, I want to just go over with everybody a little bit about what our goals are today. And as Gail said, we are going to try to make this as interactive as we can. So we will be throwing some questions out to you in the course of the presentation. And please do share your experiences and your thoughts in the chat box as we go. So the goal today is pretty straightforward. It's to become more familiar with our work. It's to identify ways that we can help you with yours, and to learn from you what different things that you are seeing in your work with immigrant survivors. And so to do that, we'll start with a little bit about who we are and our work. We are a small but mighty organization, and our area of expertise is really to help you with the complexities that can arise in your cases, focusing on the immigration relief for survivors. How many of you, and you can raise your virtual hands, your manos virtuales, and tell me who here is already familiar with immigration benefits for survivors? self-petitions, U visas, T visas. So quite a number of you already. This is wonderful. And I would really invite you to share kind of your experience with this as we go through the presentation. So how we can help you with the complexities, because something that often happens is you see a case that kind of walks in the door that seems fairly straightforward, and you know what to do and you know how to present it. And then things get messy and things get complicated, and that is really where we come in, is to kind of help with those moments where you say to yourself, oh my goodness, what do I do? And so we can kind of help you in those moments. And how we do that is through trainings. We have a number of web-based trainings throughout the year, and we often speak at national conferences throughout the year. We have a variety of resources, advisories, practice pointers, and we are currently in the process of updating our website to make it very shiny and very fancy and very useful. And the bulk of our work is really helping you with your individual case questions, as helping you answer those questions about how to present a certain issue, about an issue that comes up during processing. And the other thing that we can do for you is help you to connect with folks at the Department of Homeland Security, at DHS, or other agencies if you're experiencing kind of unusual problems or trends in your cases. And so the best way to explore all of the work that we do is through use of a hypo that we're going to work with in the course of our presentation. So if we can go to the next slide, we'll talk about Talia. Talia is from El Salvador, who entered the United States without inspection in 2001.
So what does that
Her
mean? I'm gonna explain some of the basic terms as we go through, since we have some newcomers on the call. So just ask for the patience of those of you who are experienced, and also if you want to throw in some of your 2 cents through the chat, please feel free. So what do you mean entered without inspection?
Well, before I tell you that, I will kind of say that if you know anyone who is an immigration practitioner, if you know a DOJ representative or an immigration attorney, they might as well be from Mars by the way they speak. And they speak by form number, and they speak in acronyms, and they have all of this jargon that just makes no sense to anybody who is outside of the immigration community. And so entry without inspection is kind of one of those terms. Usually that is the phrase, if you've heard the phrase EWI, E-W-I. And what that refers to is someone who has entered without inspection, which basically is that someone entered the country without proper documentation. So that is what we use by entry without inspection, that they did not pass through an immigration checkpoint when they first entered the country. So Talia is from El Salvador, who entered the United States without inspection in 2001, and her spouse is physically abusive to her and her minor children. She tells you that she tried to go to a local shelter, but the shelter staff is concerned they'll get in trouble for harboring an undocumented immigrant. And then Talia is concerned about what will happen if she is arrested by immigration enforcement. So the first thing I want to do here is just to take a moment and for you to just type in the chat box, what kind of issues come to mind here? Have you seen issues like this come up in your own communities? What do we know about Talia? What don't we know if we're thinking ahead to immigration benefits? What are some of the things that come to mind here if you work with someone like Talia who's walking through your door? So Melissa has I can do it. Melissa has an excellent point. She says, we don't know the immigration status of the spouse, whether or not they're a United States citizen, or legal permanent resident.
And that's
what
what
kind of
USC, right? So explain. USC stands for U.S. citizen, and LPR stands for lawful permanent resident.
Right, exactly. So this is the M speak. What else do they need, right? So the first thing that sometimes we go to is, do they need immigration benefits, right? But maybe they really need, kind of first and foremost, maybe they're looking for a protection order. Julia has an excellent point, right? The shelter staff should be housing survivors regardless of status. And we're going to talk a little bit about that in a moment. So is the local program, are they acting as they're supposed to? Is a question, is a concern that we have.
And can I back up a little bit on Jacob's suggestion, a question for a protection order? Just a reminder for those of you who are attorneys is that safety planning, she clearly needs safety planning. So if you're not the person who's equipped to do that, we hope that you're partnering with a domestic or sexual violence advocate who can do that for her. Okay, so which one do you want to cover first? The status of the abuser or the shelter question?
Well, I think that we kind of, there's a lot that I think that coming up with this hypothetical, in that first part, we need to think about what's the goal? As Jacob mentioned, what is it that she's looking for help with? What is the greatest need? And to be able to listen to that. And if she is thinking about immigration relief, what do we know, what we don't? We don't know the immigration status of her spouse. And that matters to determine what type of immigration benefit for which she may be eligible. As Stephanie mentioned, safety planning. Does she have a place to go? And so kind of thinking about, right, and the children as well. And then from the second point, we're going to talk about kind of in the slides kind of a little bit about what harboring is. And so we're going to talk about that now. So harboring is something that we hear about when we talk to service providers. Some service providers talk about that they do have some programs who are concerned about a survivor's immigration status. And as far as we know, there is no evidence that a victim service program employee has ever been charged with harboring. But I want to take a second to address this in case this is coming up in your area. So harboring and the crime of harboring is found in the Immigration and Nationality Act in Section 274. And it's illegal for someone knowing or in reckless disregard of the fact that a person has come to, entered, or remained in the United States in violation of the law, that they conceal, harbor, or shield from detection, or attempt to conceal them from detection in any place, including a building or any means of transportation. So I just kind of quoted that from the Immigration and Nationality Act. And so there's really kind of three elements. In some jurisdictions, they say there's a fourth. But that there's three elements to look at here. One, that a person entered or remained in the United States in violation of the law, that someone concealed, harbored, or shielded from detection in a building or a means of transportation and did so with knowledge or reckless disregard of the fact that someone was here without authorization. And so I'm going to, Patricia, maybe I will link this in the chat box, but I want to make sure that people are aware of a wonderful advisory from the Asian Pacific Institute on Gender-Based Violence that is exactly on topic, and I'll put it here in the chat box so people see. That talks a little bit about harboring and kind of concerns that service providers might have. And as I said before, there are very few cases where a person has been convicted of harboring kind of in the absence of a profit motive. So for example, that's kind of smugglers. And the risk is fairly low for agencies who offer emergency services or immigration-related services, right? helping survivors seek legal immigration status can't be construed as harboring. And similarly, we're going to talk a little bit on this, a couple of slides coming up, providing those emergency services that are necessary for life and safety are open to all individuals, regardless of status. And so we're going to talk a little bit about kind of other obligations that you may have as recipients of federal funding. But I want to kind of say that there's a good advisory on this, and generally in the work that we do for providing emergency services like the shelter does, that it really shouldn't be an option and shouldn't be a concern. And then we have here Talia, who is concerned about immigration enforcement. I want to see by a show of your virtual hands, again, whether or not you have heard from survivors a similar concern of Talia, that they're concerned what will happen with immigration enforcement. Okay. So it definitely seems like Talia is not alone, and definitely from the experiences and how many hands are being raised, it's something that you're seeing in your own work. And so this is just data that we have from a survey that we did last year that said that 3 out of 4 advocates report that immigrant survivors have concerns about going to court for a matter related to the abuse, and that 78% of the advocates who were surveyed said that survivors are sharing with their agents that they have concerns about contacting the police. Again, this was a survey that was done last year, and it had respondents from 46 states and over 700 advocates responded. And I think another statistic which is interesting there that I want to share with you is that, just one moment, sorry, I just lost my place. So it's something that I think that kind of, given the scope of the states who responded and the number of states that responded, that kind of reaching out for this outside help is something that is definitely a concern in their work. And the question is then kind of what folks are doing about it. And so as Nora had mentioned in the comments, a little bit about kind of safety planning. Now we just want to take a moment to talk with all of you, kind of what are you doing already to address kind of immigration? First of all, how many people are addressing immigration issues in their safety planning with survivors? And kind of what types of things are you doing? So you can kind of write the types of things that you're working on in the chat box.
While they're doing that, Cecilia, we can make available to them the link to the special section of our website on enhanced safety planning.
Mm-hmm. Okay. So Megan mentioned that doing kind of know your rights presentations, getting passports for children, having an officer come in to reassure that it's safe to call the police regardless of status, connecting them to immigration service providers, great. And so I think this is really good that you as advocates have a relationship, a unique relationship with law enforcement. They can kind of talk a little bit about kind of the terms by which an immigrant survivor might be able to contact them and kind of do that advance work in order to make sure that survivors are comfortable coming forward.
Great. Maybe while they continue to answer, we could explain this. I mean, it sounds like they're already providing services, but the legal...
Right, and there are a number of really important resources out there, and we can kind of provide them to you. I can find some links or provide them to you after the webinar to make sure that they have access to their important documents their identity documents, medical and financial information, that they carry the name of their attorney and their advocate on them, that they have your contact information. If they have about any prior contact with the immigration system, that they know their A number, and the A number, which is the alien registration number, which is the number that, an identification number that you will have if any prior contact with immigration before. Also, courthouse accompaniment, making sure that if people are scared to go to the courthouses, that they might have available to someone to go with them. And to kind of do that safety planning, to do about kind of who will be able to care for children if a parent is detained. Do you have at the ready kind of an ICE detainee locator? And I can share that on the website as well, that if someone is detained, that they'd be able to find them, because oftentimes individuals might be moved from place to place, and it's important to kind of have these resources at the ready. So addressing these concerns, talking about who might be able to take temporary care of children, who might be able to have a long-term care of children in the event that they are arrested or detained by enforcement. And talking a little bit about kind of what you carry on your person, and they have necessary documents that can kind of be important to their cases safeguarded. So that's what we're talking a little bit about, kind of the safety planning. But I think what we're talking about a little bit, and I think we talked about in the chat box, about educating other people of your agencies that you do, that as recipients of federal funding, you do have obligations of non-discrimination under Title VI of the Civil Rights Act of 1964 that prohibits discrimination by national origin. And that there is a life and safety exemption that, service providers, that if you are providing emergency services, that they're available to all survivors regardless of status. And there is a really wonderful letter that if you are getting any kind of pushback or problems from other kind of service providers in your agency, I invite you to print this out and wave it around. So I'll put that in the chat box. And that is a joint letter from August of 2016 by the Department of Health and Human Services, by the Department of Housing and Urban Development, and the Department of Justice, that talks a little bit about, and it has some really wonderful language in there, and that reminds recipients of federal financial assistance that they cannot withhold services based on immigration status when the service is necessary to protect life or safety. And so this was done because they had heard that some grant recipients had mistakenly believed that they were not authorized to provide services to undocumented survivors. And that's not the case. And what this letter does, if you take a look at it, is kind of outline the types of emergency services that all survivors, regardless of status, have access to, like emergency shelter, like short-term housing assistance, crisis counseling. And so I share this with you because I think access is important, and access to services is important. But also that programs receiving federal funds also have to provide meaningful access to their programs and activities by individuals with low English proficiency. And so if you and your agency don't have a language access plan, that is something that our partners like Casa de Esperanza and the Asian Pacific Institute on Gender-Based Violence do have those toolkits for you to create a language access plan so that you're providing meaningful access to immigrant survivors, and especially those with low English proficiency. And so we can pass along those information to you as well if you think that you or some of your partner agencies might need assistance kind of coming up with a language access plan. Anything you want to share, Gail, before I move on?
No, I was just going to give this as an example of the kind of more organizational system kind of advice that we can help you with. It's not just individual technical assistance. It will help you figure out how to provide services better in a more general way. And we're also happy to help you figure out how to do training and things like that locally. Sounds like some of you, for instance, have good relationships with law enforcement, and I think we would encourage you to redouble your outreach efforts to where you think immigrant survivors could get information about you, given the enhanced fear that we're seeing. They need to know that you're still there for them and it's safe for them to contact. What are we doing next, Cecilia? Here we go.
We are talking about confidentiality. And we talked a little bit about kind of the obligations that VAWA, VOCA, FITSA funded recipients, that the non-discrimination, that they can have to provide services. And also part and parcel of that is the disclosure of personally identifying information. And the government also has confidentiality provisions. In particular, the Department of Homeland Security and the Department of Justice are obligated under the law under 8 U.S.C. 1367. And we can talk a little bit about that now. And so that statute, that first bullet point, really has three main parts, and they apply to anyone with a VAWA self-petition, a U visa, or a T visa that has been filed. And they have three main prongs of the VAWA confidentiality. The first one is non-disclosure, that the Department of Homeland Security, DHS, DOJ, are prohibited from releasing information to a third party about someone's filed VAWA, U, or T visa application. And those are kind of absent very special kind of circumstances. There's pretty specific exemptions in the law. But generally, that protects an abuser from contacting the Immigration Service to get information about someone's case. The other prong of this provision is that it says that the Immigration Service cannot make an adverse decision about deportability or inadmissibility based on information solely provided by the abuser or by a member of the abuser's family. And so that is kind of a protection so that if they get information from the abuser, that they cannot make an adverse decision in the case based upon information solely provided by that person, that they would have to otherwise independently verify the information that was provided.
The reason we had to get this law enacted, and it was originally only VAWA self-petitions, some of you probably have experienced this, is that often the first thing an abuser would do when he finds out his victim is trying to get immigration status, is he would call up the local immigration office and say, oh, she just married to get status, which is marriage fraud under immigration law and is a high priority. And so the local offices said that meant they had to pick her up and detain her and try to remove her. So this law is supposed to prohibit that kind of communication from abusers, or prohibit them paying attention to that kind of communication from abusers.
And the last prong of this provision actually has to deal with procedures that are supposed to be followed if there's an enforcement action in a location that a survivor may go. And so this is found in the Immigration and Nationality Act 239E, and I'll put that in there. And this is something that I think everyone should be familiar with because it is basically a reporting requirement, that it says that if an enforcement action is taken at a domestic violence shelter, at a rape crisis center, at a family justice center, or any kind of victim service provider, or at a courthouse, if the person is there for a matter connected to the abuse, like a protection order case, child custody case, or a criminal matter, that they have to verify that they did not rely on information solely provided by the abuser in conducting enforcement actions at these locations. So they have to certify that they complied with VAWA confidentiality if they are conducting enforcement actions at one of these special locations. And so I think that's just important to be mindful of. And also things to kind of keep on your radar screen is that there is recent ICE guidance that came out about enforcement actions at courthouses. And again, I'm sorry for putting all of these PDFs in the chat box. We'll collect them and we'll make sure that we send them out to you in a more organized way at the end of the presentation. But that is in the chat box some recent guidance from January that talks about immigration enforcement actions at courthouses, that they are supposed to be against a specific individual, to avoid including family members or target individuals unless there's a public safety or if they interfere with the enforcement action, that they should avoid non-criminal settings, and they should try to take place in non-public settings. And it also outlines the reporting requirements that we just talked about, that they have to certify if they're conducting courthouse enforcement actions that they are complying with the provisions that protect survivors at these locations, that they follow confidentiality provisions. And so
I think it's worth pointing out, Cecilia, that we can help you on several levels with this kind of problem. Is that, you know, if this actually happens to one of your clients, we can help you with the legal arguments to challenge the arrest and detention and attempted. And one of the things we've always done for 20 years is to coordinate kind of systemic response. If what we see is emerging as a systemic problem, like the courthouse and other pickups of survivors, then we will work with you both on the local and the national level to bring that issue to higher ups in the agency and try to change that approach, and using their own, obviously, their own guidance. At least.
Right, and this kind of goes into that liaison kind of prong of the work that we do, is to kind of make sure that, you know.
But there's a difference between the individual liaison we do, so you know, like we'll help you with individual cases, but we'll also help you brainstorm how do you challenge a policy locally. That's okay, are we ready to move on, Cecilia?
Not quite. A little bit more on this slide. So the other thing, the last thing I want to kind of talk about here is that the confidentiality work that we're mentioning here, you're probably used to doing this in other settings. Like if the police or CPS comes to your office, you should already have processes and procedures in place to talk about what that would look like. That is someone, you know, we can neither confirm nor deny language that we can have in terms of confidentiality protection. And to kind of have a conversation with your frontline staff, to get a supervisor, to be aware of the difference between a warrant issued by the Department of Homeland Security versus what a warrant looks like issued by a court. And so again, these are things that you're already probably used to doing in other contexts. And so part of the technical assistance we could offer is to kind of help you kind of think about these issues in the context of immigration. So we raise these issues because, as Gail mentioned, they are points of our technical assistance. And so if these are things that you are seeing in your individual cases or more of a systemic level, these are things that you can reach out to us for help.
Okay, I think you need to slow down, Cecilia.
Okay, and we will now move on. Okay, now we'll talk about identifying options for immigration relief.
And can I just look back up a second? So what does relief and benefits mean here?
I use them interchangeably. And I think that their immigration benefits are a way that survivors to gain a more stable immigration status. And so, Gail, do you want to walk through some of these, and we can kind of dive in more detail to VAWA self-petitions, U visas, and T visas?
Yeah, and I would like to put these in the context of how they got added to the law.
Sure.
Of all of these, I started off doing domestic violence-based asylum. That was in the late 80s and early 90s. That was the period when that was developing. And then that stalled for at least a decade. And during that period, Congress passed the Violence Against Women Act, and that was when they created the VAWA self-petition. And as those of you who work with VAWA self-petitioners know, it's terrific, but it's limited to a certain group of survivors that you will encounter, and we will get into the details in a minute. So in 2000, Orrin Hatch was particularly interested in creating the U visa that would be a tool for law enforcement to work with undocumented victims of crimes, and as well as provide a route to that secure status Cecilia was talking about for the survivors that were helpful to law enforcement. At the same time, they created the T visa, which is for victims of trafficking. Special immigrant juvenile status was actually created in 1990 because Child Protective Services advocates in California needed a way that would to make the non-citizen children they were encountering eligible for their help. And so since then, it's been a way for kids who are neglected, abandoned, or abused by one or both parents to get status independently. Then VAWA cancellation is a form of status that you can only ask for if you are in immigration proceedings. And in general, you're not going to want to get into immigration proceedings. So you're probably only going to be working on VAWA cancellation if your client is in immigration proceedings or has an old deportation order and you're going to have to get back into immigration proceedings to cure that. So that's pretty complicated. There's absolutely an important role for the domestic violence and sexual assault advocates in those cases, as there is in all those cases, but you're going to need an immigration attorney who knows how to practice in immigration court for a VAWA cancellation. And then the domestic violence waivers of conditional residence are for those who seem to already have a green card, as we call the lawful permanent residence card, but it's going to be a card that says it expires in 2 years from the date when they originally got it. And again, that was in 1990, and that was the first time Congress created a phrase to encompass domestic violence in immigration law, and that phrase is battery or extreme cruelty. So I don't think we're going to get into conditional residence much in the rest of this, but so I'd say the main practice pointer for you all is that if you have clients who come in with a card, even if it's expired, that is a lawful permanent residence card and had that 2-year deadline on it, they may still be able to get this waiver. And the reason that's important to know is that basically they already have lawful permanent residence. They just need to get a waiver to get it free and clear. And you may not have to pursue any of these other routes to status at all. So Cecilia, you want to get into the details now a little? And people, there was an earlier question about how people can get work authorization. So how about we focus on that a little bit as we go through the individual things. Have we lost Cecilia?
No, I'm here. Can you just repeat what you just said, please, about
yeah,
the work authorization?
Yeah, let's just make sure we highlight, the path to work authorization and how fast it happens, how hard it is to get to reach it.
Sure. So the main types of immigration benefits that we work with you all on are VAWA self-petition, U visas, and T visas. And so I will briefly kind of go over the requirements of each of these, and kind of because it's going to be useful in kind of thinking about Talia and the hypo that we are using in the context of this presentation. So we have VAWA self-petitions, which are available to a spouse or child of a U.S. citizen or an LPR, or the parent of an adult U.S. citizen, son or daughter, who has suffered battery or extreme cruelty, that they have lived together with the abuser, and can show good moral character. And for petitions that are based on marriage, that they must show that they entered into the marriage in good faith. That is, that they married intending to establish a life together and not solely for immigration benefits. And so the U visa, and
should we go? I think it might be helpful for them to understand a little bit of the
process.
Nitty-gritty of this, yeah. And especially those of you who haven't done a VAWA self-petition, think about the kinds of domestic violence you see that are not physical abuse. And that is the kind of abuse that is extreme cruelty. If you'd like to share some examples of that in the chat box, we'd love to see that.
Right, and I think not only just about extreme cruelty, but I think thinking about how these applications, all of these, require paper. They require evidence showing each of the requirements of the application. So, for example, if you are showing battery or extreme cruelty, what types of documents would you typically want to submit with an application?
Right. So if you look at some of these replies, which are completely accurate, financial abuse, emotional abuse, isolation, all of those are forms of extreme cruelty that the government will recognize, but you're very unlikely to get any kind of document from a court. I mean, it's possible, and we could talk a little bit about that, or from any of the normal quote-unquote systems that encounter survivors other than you, that's going to describe how the facts your client experienced are forms of these kinds of abuse. So one of the things, I don't think we've included it in this webinar, but we have them from past webinars and we can share it, is some guidelines for those of you who are not attorneys, but who are experts on domestic and sexual violence, on how you can do what we call corroborating declarations. Because you may be the only people who can, quote unquote, interpret for the government how what your client is describing is a form of domestic violence, even though it may not be one that they're very familiar with. It's not physical battery, but it's isolation. They're all great, great ideas. And as Cecilia is implying, the challenge is how do you document them? And your client's
right.
statement is crucial. So that is worth spending a lot of time on. And you already know this from working with survivors, that it may take 4 or 5 interviews to get the true story and get the whole story and get them to focus on the pieces that are most important for the goal at hand, which in this case is qualify for immigration status. So the one practice pointer I want to mention is for those of you who are working with survivors in family court, we do trainings, actually for OVW, for judges, and some of what we train them about is to think about using that other box in the protection order context to make findings about these things. And most judges are willing to do that if you frame it as, Your Honor, this may not be something that you can actually sanction, but if you can articulate the kinds of isolation, emotional abuse, all these things that you all are suggesting in your other findings, that will actually be very helpful information for the government when they look at the person's case. And since that is all part of the pattern of abuse by the abuser, we suggest that that's something you can do. And so far, most judges have been completely psyched about doing that.
So Gail, Livia asks, do people who write support letters for the clients need to be legal permanent residents or citizens? What do you think?
Well, right now, you don't really have to identify. I mean, all you're doing is writing a declaration, right? And you don't have to say where you live or what your status is. You're mostly focusing on why you have expertise. If you're talking about family members, that's another question, right, Cecilia? Because things are getting, we can't promise, basically. We can't promise anymore that the part of the agency that does the survivor cases is not going to have to turn information over to the enforcement part of the agency. So that is a calculation that people are now taking into consideration when they're working on these cases. But having said that, and you're going to hear this from us a lot, rather than decide that they shouldn't do it, contact us, and that'll be part of our technical assistance to talk with you. Is there a safe way for them to do it that because their information is so valuable, but we don't want to put them at risk by having them help your client.
Right, and I think it also kind of depends on the individual case, right? That if you have someone who is uncomfortable putting that information forward, then that is just kind of some, is there someone else who can kind of also talk about it who might not have the same concern? So I don't think that, I think it's something that is kind of an individual case-by-case question. There might be individuals who have no problem writing a supporting declaration, but some people who might have those concerns, and we can help you think of ways to have that conversation.
And Limia, I'm sorry if I'm pronouncing your name wrong. You make another good point, which is often it's just, I'm going to short circuit this and summarize it. It's easier just to get a protection order that the abusers agreed to, and the abuser is very unlikely to agree to a protection order that has details in it. That's fine. Don't worry about that. It's just, this is, I think, a useful thing to do for the clients. It'll help, and also it's a way to start educating the judges so that if they encounter someone who doesn't have an advocate or attorney like you helping them, they start thinking about that themselves. That, well, maybe it might be useful for me to offer to do this. So shall we move on to U visas, Cecilia?
Let's. But again, so part of what our job is to start thinking about what that documentation is to go forward in supporting these applications and showing the good faith marriage and showing the joint residency. And U visas, NT visas, were created, as Gail mentioned, in 2000 with a dual purpose. One is to encourage individuals to, one is to be a tool for law enforcement to investigate and prosecute criminal activity. And the other purpose is to provide protection to these survivors who are coming forward. And so it's really important as we're thinking about U's and T visas to think about that dual purpose at the front of our heads. This is the purpose for which these benefits were created. So for a U visa, you have to be a victim of a qualifying crime. The full list is in the statute. There's something like 30 crimes, and generally they're kind of crimes against a person. And so if someone just kind of breaks into my car, that's not going to give me a U visa. So the full list of crimes, it includes domestic violence, it includes sexual assault, it includes trafficking, it includes abusive sexual contact. And so crimes that we might see in the course of our work. That they suffered substantial physical or mental abuse as a result of the victimization, that they had information about the crime, and that they were, they are, they will be helpful in the investigation or the prosecution of the crime. And generally that requirement, the requirement of a U visa application is a law enforcement certification that talks about the helpfulness of the applicant and talks about the qualifying criminal activity. And so the certification, as you know, is a requirement of the U visa. And where you might not have that requirement to reach out to law enforcement for the valid self-petition. And the last part of the U visa is that they are admissible or eligible for a waiver under this section of the law, 212D14, which is in the national and public interest. And I would have to say that 80% of the technical assistance that we offer are connected to these inadmissibility waivers. And thinking through the complexities of applying for these forms of relief when somebody has a complicated criminal or immigration history. And I think that part of it is that we do is really important because oftentimes what we try to do is kind of combat this perfect victim fallacy. And that every case is going to be clean cut, and that's often not the case, that people do have complicated histories and complexities in their case, often as a result of the victimization that they have suffered. And so we're kind of happy to field any of these kind of complexities as they arise in your case.
And Lydia, a point about certifiers, I think. So other than the obvious law enforcement, police and DAs, who do we see certifying for UV?
Judges
Sometimes.
are
Sometimes not.
Yes, sometimes they can be certifiers, and because part of what under the regulations, under the laws, kind of has been defined as investigation or prosecution includes the detection of criminal activity. And so that is oftentimes the way that judicial officials have been involved in the issuance of certifications. But beyond that,
just so I can drop a note, because their big issue is the appearance of bias. So when we train them, what they usually say is, well, I certainly couldn't do this until the case is over, because otherwise it would have the appearance of bias. And sometimes they say, I don't know if I actually detect a crime in the protection order context. So again, this is where we will work with you on how to work with your judges, because it's really going to vary by judge, frankly, whether they'll be certified. Yeah,
right, and the issuance of this, the issuance of the certification by itself is discretionary, right? And so that is a challenge that we see across the board. And this is apart from judicial officials, that oftentimes you have jurisdictions who do not engage in certification practice at all. And so I think that the certification issue has been and remains a complexity in U visa cases, just given the variance of how different jurisdictions have engaged with the program.
And then we have the other federal, state, or local agencies that may do it if they detect, investigate, or prosecute. So what have we seen? What kinds of agencies have we seen certified?
So the Department of Labor has a certification policy that there's a certain number of times that they have designated that they will be certifiers for in the course of their investigation. The EEOC can also be a certifier. And also, backing up to the Department of Labor, that there are also kind of state departments of labor who are also going to be certifiers. Children Protective Services can also be certifiers. The National Labor Relations Board. And so these cases kind of come up in the workplace context. And I would encourage you, if you don't have this a part of your intakes already, to kind of talk with survivors about what experiences that they're having in the workplace. Because oftentimes they might be experiencing sexual abuse or sexual assault in the context of their work environments as well, which might open up kind of opportunities to kind of look at these other alternative certifiers in cases. So if you're not asking about issues in the workplace, I definitely kind of encourage you to kind of add on to that, to start doing some issue spotting in that environment as well. And so T visas, just very briefly, are for victims of severe forms of trafficking, and that is defined kind of in the law. I always just think it's interesting because what form of trafficking isn't severe? That they are present in the United States on account of the trafficking, that they complied with reasonable requests for help in the investigation or prosecution, and they would suffer extreme hardship if they returned. And so the complexities that we see in T visa cases often have to do with the physical presence, the on account of issues. But unlike the U visa, T visa does not have a requirement of a certification, that they can use secondary evidence or rather primary evidence to prove helpfulness in the way that the U visa does not have that. The U visa has the required certification, and in the T visa context, you do have the opportunity to submit other evidence of the helpfulness requirement.
And they have never used all the T visas in a year, as far as we know, right? Whereas the U visas are way overbooked right now.
Right, and I just wanted to circle back because I'm noticing the captioning. I just want to make sure that that I'm clear that the in the T visa there's no requirement of a certification, whereas in the U visa context that there is a requirement that law enforcement sign a certification that the applicant was helpful in the investigation or prosecution of the crime. Thank you.
And we will probably do, we're thinking we should do a webinar on how to turn your U visas into T visas as an option. Because I don't think, so maybe we should backtrack now, Cecilia, and talk about how long it's taking and when people are getting work authorization in each of these systems.
Sure. So the speed of work authorization, I'm going to give you my lawyer answer. It depends. And so, for example, if you are filing a VAWA self-petition and the abuser is a United States citizen, you may be eligible to apply for what we call a VAWA one-step, where you submit the self-petition together with an application for your green card. And in that instance, you might be able to get work authorization because you have a pending green card application. And so that might be kind of a way that you would get employment authorization. You also are eligible for employment authorization. For example, let's say the abuser is a legal permanent resident, that you would be eligible for work authorization upon approval of the VAWA self-petition. And right now, kind of those processing times for VAWA self-petitions, that means that they are now currently working on cases that were filed October 31st of 2016. So it's how about a year and a half out. And for the U visa, you are able to get work authorization when your case is placed on the wait list. And right now, the processing times for those applications is August 25th, 2014. That has been the same processing time since for the past 11 months. It hasn't moved since then. So it's quite ways away out.
What does that mean?
It means that, I'm sorry?
Does it mean they've done all the cases filed before that date, or that if you have a case filed after that date, they haven't even opened your file? Is that what it means, or something else?
Yes, it means that if you have a case that was filed before then and you haven't heard anything, it's worth following up to see what's going on in the application, and we'll tell you a little bit about how to do that in just a moment. And it means that if you filed after that, then you probably won't hear until those processing times move.
So how does the U visa system work? Well, when you say the processing time is 2014, if they're opening a 2014 file, are they actually giving people a U visa?
No. So what happens is, so for the U visa, there is an annual cap of 10,000 visas, and that goes for principal applicants and not just for family members. And so they have hit the cap every single year since 2009. But so if a visa is not available, then what they do is they put an application on a wait list. And basically that wait list says that you have an application that is approvable. But because of the cap, there's no visa to give you. So we're going to give you a deferred action, and you can renew your work authorization. You can work in deferred action and then a work permit kind of based on that deferred action status. And so you would get that until such time as a visa becomes available. And so what happens is that the number of applicants has grown exponentially in the U visa context. But right now, there are 110,000 principal applications pending at the Vermont Service Center. And so this means, that some percentage of these, let's say they're approved, that it can be quite a long while until a visa is available given that cap. So the August 2014 processing date is for placement on the wait list, not for issuance of an actual visa.
And that's when they get that deferred action EAD that people hear about.
Correct. Correct.
But
So
EAD
how long?
Employment. EAD stands for Employment Authorization Document.
Right. And so there are 60 adjudicators working on the U visa unit, and so there's not a lot of people working on a very high number of cases. And so that is the reason why kind of we've seen these processing times kind of stuck for so long.
It's also why we think you should go through, if you're doing these cases, you need to go through your U visa caseload and see if people have married a citizen or lawful permanent resident or might actually qualify for a T visa. Because those are still, I think, much faster. What is the timing on getting work authorization for a T trafficking victim?
It's right now it's almost a year. They're working on cases that were filed April 3rd of 2017.
But once they open it, they actually grant the T visa, right? There's no wait list.
Right. Of course, so there's a $5,000 cap on T visas, which they have never hit since the creation of the program.
Just they take a long time to do any of these cases, mainly because I think it's the same unit that does all three of these kinds of cases.
Mm-hmm. All right, so let's go back to Talia.
All right.
So these are the points that we had from before. We knew that she entered from El Salvador without inspection. This is 2005, but 2001 doesn't make a difference. We have the physical abuse, and we have the issue with the shelter, and we had talked about her concerns about reaching out and her concerns about immigration enforcement. So here are some new facts. So let's keep those forms of relief in mind, and we can kind of go back and forth. But now she's married to a U.S. citizen who's been physically abusive. She called the police where her spouse was violent toward her and her 7-year-old son, and she's willing to testify at trial. And she also says that she works at her spouse's business and hasn't been paid. And when she asked to get paid, she said that immigration would deport her since she's working without permission. Okay. So now, given these facts, can people tell me in the chat box kind of what they're thinking of in terms of potential immigration relief and why they're thinking those things?
Follow one step, and that would be based
right.
on the first one, right?
Mm-hmm. Mm-hmm. Yep. Josh says, get her that work permit. Right. Right. Potential T, right? Because there is instances where she might be kind of working or having some kind of labor trafficking and some forced fraud or coercion, especially because we don't know kind of what other issues she might face if VAWA is going to be a good option for her. But mainly we're thinking VAWA, right?
So
but there is. What about the second point? Oh, go ahead, sorry.
Because a lot of people are saying VAWA, but Josh makes a good point, which is what if there are bars to adjusting under VAWA? So we should, first of all, explain what adjusting is. That's getting your lawful permanent residence. And
here in the United States.
Yes, here in the United States. And at that point for VAWAs, that's when they have to overcome those rules called the grounds of inadmissibility. And there are a couple for which VAWAs cannot get a waiver. I'm wondering, Josh, if you happen to know what the most likely one is?
I'm going to talk about it later.
So, and this is a good point because you don't want to wait until your client is about ready to go to their local, they have to go to a local CIS office, Citizenship and Immigration Services office, to have an interview to get a green card. You don't want to have waited until that point to figure out she's going to get denied when she shows up at that interview. Yeah. So there's a bunch of them. Josh is actually mentioning one of the more complicated ones, but the most important one is if your client has ever told any person in an official capacity, immigration, a state, local, or federal officer, for purposes of getting any kind of benefit, that she is a U.S. citizen. That's what's called a false claim to U.S. citizenship, and there is no waiver for VAWAs for that. And we have seen this happen. People have failed to find that out. They've gotten the self-petition approved. They've sent their clients to the local office, and they've been picked up and put into deportation proceedings because they had a false claim to citizenship. I'm sorry, I'm talking very low. So
what about the second? Okay, go ahead. Sorry.
So just shorthand, false claims to citizenship. Really important to figure out now when you're doing a self-petition. Don't wait until your client's ready to file for the green card.
What about the second bullet point here? Yeah. What do people think about this second bullet point? What comes to mind on that one? Right. So Nora says that we can potentially be in U visa territory as well. But this is kind of a wonderful spot to be in. Sorry, that was a weird thing to say. But you have this situation where someone is potentially eligible for more than one form of relief. And so that is something that you need to think about. What are those different factors that go into that type of decision? We have speed of processing time. We have processing times. We have when do we need work authorization. We have what is the complexity of our inadmissibility issues. Are there other family members who could potentially need to be considered to be derivatives? So there's a lot of different factors that can go in which it might be the best form of relief available. And that is another kind of point where we can come in and give you that technical assistance. If you are kind of choosing between multiple options, kind of thinking about, what are all those different factors that are important to people. If, for example, a derivative is another family member who might potentially be eligible for immigration benefits.
And Josh also correctly identified special immigrant juvenile status as a possibility for the child. So that was smart.
Yeah.
Do they have to choose between these, Cecilia, or could they do more than one application if they qualify?
They can do more than one, but in those situations, what I would recommend is that you give the Immigration Service some sort of guidelines how you would want things adjudicated. So in this case, let's just assume she's eligible for all three. You would say, okay, Vermont, you're doing a VAWA self-petition first and see how that goes, and depending on that adjudication, please proceed to the T or the U. So you can do more than one form of relief, absolutely. But it's always a good idea to kind of give the Immigration Service, when you're filing these applications, some guidance on how you would want them to be adjudicated. And good job, Josh, on the SIJS option. Okay, so here's where things can get complicated. Talia has a recent conviction for assault. When her spouse tried to choke her, she scratched her spouse's arms in self-defense. When the police came, they saw the scratches, and she was arrested. Talia was issued a notice to appear, an NTA, but didn't go to her hearing because she didn't understand what was happening.
So could you clarify what kind of hearing you're talking about? And I hope people can now hear me. I'm doing what I can here.
No, you must sound much louder.
Okay. Okay.
So a notice to appear is a document that starts proceedings in immigration court. And so it's commonly in immigration speak called an NTA. And that is kind of how you know that you are in removal proceedings, is that this document has been issued to you. And what I did commonly is I print out, and we can do this in our sample materials, is I had a redacted or a sample NTA. And I was kind of, in the course of my intake, saying, have you ever got a piece of paper that looked like this? And so that is a way to kind of see whether or not someone might have had any other prior context or contact with an immigration court. So here's some facts that we have here. There's a recent convictions for assault. They have an NTA, but they didn't go, understand what's happening. And Talia's spouse told her to lie about her immigration status to get a job. What are our thoughts here? Any of these deal breakers? What kind of are your most pressing concerns looking at these facts?
Right. So for the missed court date, Lemia is pointing out that you will need to she's going to eventually need to get back into immigration court, and you will need an attorney or a BIA accredited rep who can practice in immigration court to do that. But it doesn't mean they can't qualify for status, right, Cecilia? Necessarily? If she missed a hearing?
Not necessarily, no. Nope.
Okay, good.
But as Josh and others have kind of said, you do need to kind of start a different line of questioning, right? How long ago was that? Did you leave the country after you got that and come back in? So I think you need to it is an indication that you have to ask more questions, right? And again, looking at that third point, it also might be an issue where you need to ask more questions. Can anyone tell me why?
For the lie about her status?
Mm-hmm.
Okay. And while they're doing that, Lemia has pointed out that her assault is probably something you could overcome because it's linked to the abuse. And the unit that does these cases should be well trained on understanding that abusers often do that. But again, if you have a case like that, you should contact us because we'll help you figure out how to frame it for them and provide them the documentation to explain that to them.
Right. So we don't know what the immigration status is. And I think as many of you have correctly identified, if she said that she was a U.S. citizen, that might be a deal breaker if we're looking at a VAWA self-petition, right? And so I think that that's kind of one of those facts where you're going to want to find out a little bit more information. But again, all of these are points where you could reach out for us for help if this is something that you are not used to seeing, or if you're coming up with a new admissibility issue or a new complexity, which is kind of knocks you off your feet. You know, I've had cases where someone told me that they were, you know, married to their home country, and then they got married here, and then you're just looking at all sorts of complexities. And so these are all points where you can kind of reach out for us if this is not something that you're used to seeing in your practice or a new issue that's come up for you.
And there are very few bright lines. So while it is true that lying to get a job may be fraud, it may not be too. So it's really very fact dependent. And so just don't, in general, my advice to you is never assume no. Always contact us to see if there's a way to yes.
Right. And the flip side of that is also not to overpromise, right?
Yeah.
Because you see someone is married to a U.S. citizen and they have a protection order, where you say, oh my goodness, no worries, you're totally VAWA eligible. Because if we're not asking questions to find out about these details, we could be sending someone down a path for a benefit for which they're not eligible. And so I think, as Gail mentioned, it's important not to be judge and jury about a particular fact, but I think that goes for both over-promising and under-promising. Okay, now you file your application. Let's assume now that Talia did not say that she was a U.S. citizen, that she filed for a VAWA self-petition. And her case is beyond processing times at the Vermont Service Center.
So just to clarify, that means she filed something that was dated earlier than the times they are saying they are looking at in their cases right now? So that they should be considering her file?
Yeah, because, yes, that's there. Okay. Everything has been filed, and so now she filed something that is beyond those posted processing times. So as we said before, the Vermont Service Center is the office for which they have a VAWA unit where they accept applications for VAWA U's and T visas. And so right now, let's assume that she filed a VAWA self-petition in July of 2016. And now we have the processing time that's posted is October 31st, 2016. Okay? And so something that we can help with at this point, like obviously if you reach out to the VAWA unit, if an individual is represented, they do have a hotline by email or by phone that you can reach out to if a case is outside processing time. We're going to share that email with you later in the presentation. But we encourage you to reach out to them for cases beyond processing time. And we encourage you to reach out by email because that way you have a record of the back and forth. I think sometimes the response time is faster on the phone, but again, you lose that record if you're only doing something that's over voicemail. So if you don't get a good response from the hotline, this is another technical assistance point where we can help you, that we can kind of help raise your concern to the folks who are at the Vermont Service Center to see if we can find a way to help unstick this case. If you get a request for further evidence in your VAWA case, or an RFE, because saying that she doesn't have good moral character because of her criminal history. When you get an RFE that you think misses the mark or doesn't understand the law, or even if it's just something that you just haven't seen before, a lot of RTA deals in RFE response. So if you get something that you think is just kind of out of the ordinary, please do reach out for us. And now we have the fact that Talia is arrested and detained by immigration enforcement before her VAWA case has been decided. So breaking down all of those points, we have kind of the good moral character issue. And this is all pursuant to a wonderful memo. It's one of my favorite memos. And yes, I have favorite memos, and you do too. That talks about good moral character bars in the context of VAWA self-petitions. I'll add this to my ever-growing list of things to send out. And it provides this kind of analysis for purposes of VAWA. So does the bar, inadmissibility bar apply? Or does the good moral character bar apply in the case of this assault conviction of Talia's, right? And if it does apply, is there a waiver available? And is there a nexus? Is there a nexus between the conviction, Talia's conviction, and the abuse that she suffered? And I think the answer here is undeniably yes. But if you get an RFE for this, remember that the adjudicators of the Vermont Service Center, many of them are not lawyers. And so I think that these are sometimes in RFE responses where you have to kind of break down some of the authority and how that applies to your case and kind of do that analysis.
It seems to me Cecilia, that that's the perfect example of where you really need a lawyer and an advocate working together. Because the lawyer is going to do the does the bar apply and is there a waiver available piece. But I imagine those of you who are advocates are going to do a much better job of helping show the connection to abuse than a lawyer, because very few immigration lawyers have actually been trained up on domestic and sexual assault like you all have.
I agree.
Okay.
So Gail, do you want to kind of talk about how we can help Talia if she's arrested and detained before her vow is approved?
Right. So this is actually, we're spending a lot of time working on this nowadays, and our arguments are constantly evolving. But again, I cannot emphasize enough how important it is for you to contact us as soon as you think you have a survivor who's at risk. Because there's some things you can do to set up your case if you're filing, or to fix your case if it's already filed. And there's some other steps besides the safety planning, some legal steps you may want to consider to ensure that if your client does get picked up, you're ready to roll with the actions that need to happen to stop the removal. And you will need an immigration attorney for those kinds of actions. But again, I think it's really important for those of you who are domestic and sexual violence advocates to help articulate why it's so important that this person not be removed. So we would be working with the attorney on how to make the legal arguments based on the government's own memos about why it shouldn't be trying, or if it's going to deport a survivor, what steps it has to show it's gone through first, and we need to make them do it. But then also the arguments you're going to make to the ultimate decision maker, which might be an immigration judge, it might end up being a federal court judge, or it might be the Vermont Service Center, about why, in what they, a term that is used a lot in the law, in their discretion they should grant. So discretion is kind of this black hole in the law, because you can make legal arguments till you're blue in the face, but if they have discretion, what they're really looking at is their own, looking at the pros and cons of your case and making a decision based on that. And they have a lot of leeway in how they exercise discretion. And that's where I think those of you who have expertise in domestic and sexual violence can really help beef up those discretion arguments. So again, contact us as soon as you think you might have an issue so we can help work through all these steps and prepare. Is that enough, Cecilia, or did you want me to say more?
No, that's totally fine.
Okay.
And it's something that we are thinking about in the course of the webinars that we are planning for grantees, talking a little bit more about kind of removal proceedings and the technicalities of that as well. So be on the lookout once we kind of get that schedule together. So how do you get started? If you've never asked us a question or reached out for technical assistance, and we hope that you do, the first way, we want to make sure that you are in our database, and so by following that link, you should be able to get connected and make sure that you are in our system as a grantee. And so that is the first thing that we invite you to do. Gail, let's talk about the second bullet point.
Right. So even for those of you who are advocates, I would say that I view part of our job is to teach you how to think about this, not to spoon feed you the regulations and the statute. So we will point you to the things that you need to read, but if you get me, I'm going to make you actually read the statute and the regulations and the memoranda yourself, and then we'll work back and forth on how you are analyzing and using that. Because the idea is that once you do that once with me, you're not going to have to come back every time you have the same case and ask the same question. So, and that once we're gone, or once you're gone, you'll take this knowledge and be able to teach others and use it in other situations as well. So I hope that, the advocates are up for this. The lawyers should be familiar with this. I think it's really helpful for those of you who aren't lawyers to also start learning how lawyers think. And partly because this other project that's funded by the Office on Violence Against Women, that's run by the Catholic Legal Immigration Network is to train advocates up to be what are called Board of Immigration Appeals accredited representatives. And we work with them on this, and Cecilia and I help with the trainings on this. And one great result, an example, is that several years ago, the Wyoming Coalition Against Domestic Violence got recognized by the Board of Immigration Appeals as an immigration law service provider, and many of their advocates were recognized as accredited representatives. And that was really important because there were so few nonprofit immigration attorneys in Wyoming. Most of these cases, you know, the survivors can't afford to pay an immigration attorney. So what we really need is to expand the services for those who don't have the money to pay a regular attorney. Plus, frankly, you all will probably do a better job with these kinds of cases than an immigration attorney who isn't taking this kind of specialized training. As the other immigration attorneys on this call could attest to, there are many attorneys and quote-unquote notarios out there who will offer to get people a green card for like $5,000 and do a terrible job, and the person gets deported and there's nothing that can be done. So we strongly encourage you advocates to pay attention to the outreach we'll be sending out about those trainings, and in the meantime, we would love to work with all of you to kind of learn how to do the legal thinking so that you can do it on your own. Did you want to explain the hotline to them, or I think we kind of covered that.
Yeah, we talked about the hotline. These are the email addresses. I think the one that is not on there is the email address that is for the Nebraska Service Center. The Nebraska Service Center has a U-Visa work share with the Vermont Service Center for some of these older U-Visa cases. So if you've got a transfer notice that your case is at the Nebraska Service Center, they have their own customer service hotline, and we can make sure that we send that out to you in the materials as well.
Okay.
But generally, if you have something that is delayed or outside of processing time, we definitely invite you to kind of take advantage of the hotline first. And if you don't get a response or you don't get a good one, then definitely follow up with us, and that's something that we can help you with as well.
Also, Cecilia, I think if it's your first time contacting them, definitely work with us, because I think there are ways to make it something easier for them to figure out than others. We've had a lot of experience communicating with them, so we can share some of that with you. Yeah, Nora has a question about the unlawful practice of law. That's part of the whole training that we have with clinics. And we're happy to share the resources on that, but you're absolutely right. You've got to avoid the unlawful practice of law if you're not an attorney. And we can get into that some other time, but if you're working with us, we'll figure that out on an individual level for you. How's that for an answer, Nora? Not a real answer, but that's all we can do for now.
Right, but that's why the DOJ accreditation program is so important.
Right.
Because that is a way that you can kind of make sure that the advocate has sufficient training, has sufficient guidance and supervision, and has that infrastructure around it so that they are able to kind of, in a kosher way, kind of do the work in terms of filing these types of applications. I think it's a very important consideration. And
right.
one that which the DOJ program was designed to address.
Right. So the DOJ, if you are accredited, DOJ will not view your work as the unlawful practice of law. It's very unusual. I don't know of any other part of our legal system that has this. But it's really important in our system because there's so few nonprofit attorneys and they're so swamped, as those on this call I'm sure can attest. So,
okay,
now
so
we're
now
just
we want to take,
opening up.
Yeah, go ahead.
I'm just saying, now we're just opening it up?
Mm-hmm.
Great. Do we have a resource slide we should post while people ask questions? Yeah. Great. anything you want to talk about, now's the time.
Right. So if you have questions in the context of things that you're working on now, trends that you're seeing, we definitely want to kind of take some time to talk about that. If you need to jump off to your next thing, you have that call you need to make or that email you need to send, please, here's our contact information so that you can reach us after today's webinar. And for the technical assistance, we invite you to register with us and kind of ask questions through our system. But we're glad that you took the time to be on this webinar, and thank you for spending part of your morning or afternoon with us. And we'll be around for the next couple minutes if you want to share the types of things that you're seeing, the types of questions that are coming up in your cases, and or anything else that you might want to provide.
And Patricia, there had been a question about whether people could get the transcript later. Is that possible?
Yeah, I replied to the person, but I'm not sure if she saw it.
Okay.
Let me go ahead and copy and paste the captioning link, and participants can go ahead and download a copy that way.
Okay, so Paula has a question. If your client is unable to obtain a copy of the birth certificate to show that the spouse is a U.S. citizen, what else do we recommend? And so I think this is a minute where I just want to show that the standard of evidence, or what you need to show for a VAWA self-petition or any of these forms of relief is the preponderance of the evidence standard, right, which is kind of about 51%. And how you meet that standard is what they call any credible evidence. And that standard was created kind of in express recognition of the fact that individuals who would be applying for these forms of relief were escaping abusive situations and might not at the ready be like, okay, I need a copy of my spouse's passport or birth certificate, and I need X, Y, and Z document. And so that is why they created this any credible evidence standard, because of the recognition that that survivors of domestic and sexual violence may not have the same access to evidence as in other situations. So for showing spouse's status as a U.S. citizen, you can kind of submit any other evidence. Sometimes marriage certificates have the place of birth of the spouses. If there's any other kind of documentation in terms of that has place of birth, maybe insurance documents or school documents or anything else that might kind of list the person's place of birth. The client's own declaration, how they know that they're a U.S. citizen. And then other times if the person is a naturalized citizen or LPR, there is, pursuant to the regulations, a way that you can ask USCIS to independently verify their status. But you would have to give as much information as you have. If you have an A number, or if you have a social security number, a date of birth, and you would have to just basically say, I don't have this evidence because I left an abusive relationship. I've tried to find it by doing X, Y, and Z, and this is why what I am submitting is credible. And so I think if you don't have that kind of primary evidence, that you can kind of look for other documents that might have that place of birth if they're born in the United States. Other words, kind of address it in the client's own declaration or try to get kind of that secondary evidence of that.
Okay, now Cecilia, I know you, yeah, I can take the other ones. I know you need to go run and pick up your kids. So if you want to, I'll do the other questions and you can just leave when you need to. So for everybody else, this is an example of the kind of technical assistance that we will do for you. Looking at Melissa's question, which she had asked before, as I mentioned to her, this is really a statute parsing question. So what I would make you do, which I'm going to do right now, is go to the actual statute. Section 204 of the INA is where the VAWA self-petitioning section is. And you'll see there that it's broken up into little pieces. So, and this is why I always have to read the statute, because I could never remember what has to go together. So it says during the marriage or the relationship intended to be a marriage, which is a whole other thing, the applicant has to have been battered or subjected to extreme cruelty. So my reading is that you have to show that at least some of the abuse occurred during the marriage. Now, those of you who are familiar with domestic violence know that often there's abuse that started earlier before the marriage, and that may have been the worst abuse, but as long as some sort of abuse occurred during the marriage, even if she was willing to take it until she got married, and then she'd had it and got divorced, you can probably show some sort of the abuse occurred during the marriage. It does not, the residence section is separate. So if you look, that's why I say you got to parse the statute, because the residence just says that, where is the residence section? This is a very complicated part of the bill. But as I remember, yes, you have to show that they resided with the abuser at some point. And that actually got changed in the law, because at one point it either said resided during the marriage or it said resided in the United States, and we were seeing a lot of abusers, bringing in their spouses to the United States and then setting them up in a separate apartment. So now you just have to show they resided somewhere together, which could be in the home country. So again, I think when you have specific facts, it's easier, but that's the basic parsing, I think, Melissa, of what you were talking about. And then Josh is asking about...
Yeah, I can address Josh's.
I'm shocked. I'm kind of shocked they replied to his client, aren't you?
It's through the National Customer Service Hotline and not through the hotline. And so,
okay, well, you go for it.
Kind of yeah, I think so. The question is kind of when this is kind of an example of the systems problem that we can try to address through our technical assistance, because it is really disconcerting. It's disconcerting if you are telling the client one thing and then there's something that happens where not only where there's an action that's inconsistent with kind of how things are supposed to work. And so after, Josh, you get the notes from your call, please do follow up with us, because this is something I think that people would want to know is happening, and making sure that the information is being accurately and safely provided. Because that's the really thing that's concerning, that those non-disclosure provisions of vow of confidentiality are supposed to be in play, and really want to make sure that there are those kind of benchmarks of confidentiality that they're supposed to be applying with. So please do follow up with us.
2 things on that, Cecilia, right. Everyone needs to know that the special hotlines we gave you will not take inquiries from your clients directly.
Right.
You have to supply what's called the G28, which is the form filled out by the lawyer or the accredited rep that says they represent it. So that's completely a security issue for survivors, is they don't want the abusers contacting them, and how do they know that the person contacting them isn't the abuser? Then the second piece points, one of the main things that we do for you guys is we will raise an issue like Josh's to Citizenship and Immigration Services headquarters, the policy people, and say, did you know that this hotline is saying this to survivors, which is a really bad thing? We assume you agree, and can you fix it? And we've done that in the past with similar kinds of issues, and they usually figure out some way to fix it so it doesn't happen again. Okay, so I think there was another question earlier. Lemia asked, does it matter what kind of divorce you get to qualify for a VAWA, whether it's annulment or another kind of divorce? So I don't really have enough facts to know which way this cuts, but I'm going to give 2 examples. Let's assume you're talking about a prior divorce with someone who isn't the abuser. And so you're trying to show the applicant is not a bigamist. There is a general principle that CIS is not going to consider divorces as legitimate for immigration purposes if it was done in order to get an immigration status. I don't think you're going to see that very often with these VAWAs. It's usually just going to be that they came to you and now they're married to usually another abuser who qualifies them for VAWA. Annulment, and it doesn't really matter. Annulment's a little better, but again, the question they usually look at was, did you do it in order basically to avoid a negative immigration assumption? Let's flip it and assume you're talking about the abuser. So it's one thing we didn't get into because there's so many nuances to VAWA self-petitioning is that survivors who are married to someone who turns out to be a bigamist can still qualify. They have to show that they, in good faith, married the abuser thinking that he or she was eligible to legally marry again. And again, I don't think it matters that much whether it's an annulment or another kind of divorce, but let me posit a third one, which is actually in the very first memo that was issued by Alex Oleinikoff, I think it was in 1997, after VAWA was passed, right? And it said, because what you'll see, back then we didn't have the 2-year exception. It was you had to be legally married on the day that you filed, and that would lead abusers to run to the courthouse and try to get a divorce so that their victims no longer qualified. And it's a great memo by Alex. He said, essentially, if the annulment was a part of the pattern of abuse, then we're not going to consider that a legal divorce. And now you don't have to worry about it so much because you have this 2-year period where you can still qualify for VAWA if you've been legally divorced for up to 2 years. But you still need to have some ticklers in your file. Like you don't want to wait beyond 2 years from a divorce to file for a VAWA self-petition. Did you have more, Cecilia, on this?
Yeah, but just like that, no, to really, I mean, it's a wonderful memo. You know how I feel about memos. And they say that legal termination of the marriage, whether by divorce, death, or annulment, after the self-petition is filed will not be the basis for the denial. And so I think that it's really worth looking into. It's a good authority.
So, Lemia, what you say about the immigration attorney telling your client that was disinformation or misinformation, and this is why we don't think survivors should be going to regular immigration attorneys unless we know who the good immigration attorneys. Let's put it that way. There are plenty of private immigration attorneys who do know this stuff, but I would still say that's like a small percentage of the total immigration lawyer population. And unfortunately, it seems like a typical characteristic of many lawyers is that we don't want to admit when we don't know something, so that they'll give a bad answer rather than actually call us, for instance, to find out the right answer.
And again, I mean, a lot of this can be nuanced, and so, but if there's anything that, you know, for example, about kind of what the process is, and so, you know, never, you know, hesitate to reach out to us if you just have kind of a question about issues like this. To Melissa's question, is there time for that one? So Melissa's question says, can you have an I-130 open at the same time as you file an I-360? The answer, I think in this situation, this happens commonly where you might have a one-step that is put together with the spouse, and then there's domestic violence. And so what has happened and what some people do is that they are able to, they ask to basically kind of sub out the I-360 for the I-130, which is a family petition, and saying like, listen, my client now wants to proceed on the basis of an I-360, and that they hold the adjustment application in abeyance until such time that the I-360 is adjudicated. And in those situations, I think that you need to do some really important safety planning with the survivor, particularly because there's another pending matter with the abuser. And so there were these kind of systems in place in which you once you send that notice saying, I want to hold the application, the adjustment application in abeyance, to invoke those VAWA confidentiality provisions, saying, I want you to the obligations that you have under 8 U.S.C. 1367 regarding non-disclosure of information. And so I think depends on where you are in the process, if you're closer to the interview stage or something that has just been filed. I think those details we can help you out with, but it's something that is very commonly done.
Cecilia, can you hear me now?
Perfectly.
Okay, good. I managed to disconnect myself. So just one kind of higher level point on this is that we had gotten this agreement from, at that point it was the INF, to follow the process Cecilia is talking about, but they never wrote it down. So now, that was literally, 25 years ago. So now with the turnover at your local offices, many of them don't know that this is the proper procedure, but it seems like I've been continuing to send to the policy person at headquarters who does in charge of VAWA cases the examples of the problems with certain districts, offices of Citizenship and Immigration Services, and I think that's been helping. So this is what Cecilia said is absolutely what they should be doing, but a lot of them aren't going to know it. So again, don't wait. Contact us if you think this is going to happen so we'll help you figure out whether you're likely to run into a problem at a local office or not, and if you are, help you figure out some steps to avoid that problem happening. And Melissa, at least in the past, your question was, do you need to close the I-130? At least in the past, what worked was just to say we want to switch the basis of the adjustment from an I-130, which for those of you who don't know is a normal family-based petition, and they will often exist in a VAWA case, that you want to switch the I-130 with the I-360 form, which is the self-petition form, as the basis for adjustment. Do you see any other questions? I see Lenia's typing, but did we have any other questions we missed, Cecilia?
Right. The only thing I would think about with annulment that would make me be nervous that the annulment was being sought on the basis of marriage fraud. I think that is where we have to doing some deeper technical assistance on those types of issues. Right. But that's the only thing that I think makes me a little bit more nervous.
So that's actually a good point, right? I think that if things are happening in other systems, these are the things you need to contact us right away. If someone's alleging marriage fraud, even in any other context, civil or criminal, if there's anything going, if your clients are being charged with anything, we need to talk to you, because even if they plead to something, they're likely to have a conviction under immigration law for something that will get them deported. So in general, it's really important to be telling your clients, don't plead to anything until we check with the experts. Because unfortunately, many defense attorneys will tell survivors to go ahead and plead to, say, a domestic violence charge because it's easier than going to trial. But for a survivor, that means they're going to get deported, and they will never get status. If they get convicted of a domestic violence crime, it's going to be extremely difficult to overcome that. Although we do, as we talked about earlier, there are arguments. But let's try to avoid that. So, shall I take this adjustment question?
Sure.
Okay. So there's an adjustment, AOS, for those who don't know, is adjustment of status, held in abeyance, probably pursuant to that conversation we were having. The VAWA petition looks like it's been approved, but you sent a letter, I assume, to the local office to start the process, and nothing's happened. So no, I don't think it should be taking that long. Why don't you, like Cecilia was saying, I think you want to forward us what you've got, and we will work with you to figure out how to record your attempts to get this fixed, and then we take that to headquarters and try to sort out what's going on. Are you still around for a couple minutes, Cecilia, or do you want me to just keep doing these?
You can ask you the questions. I'll have my phone on, so I'm happy to help, but I'll be away from my computer.
Okay, so then Gail asked, I filed a U petition for my client. Will she be able to apply for a work permit? So
eventually,
it depends.
Is the answer.
Yeah, why don't you're more on top of the processing times than I am, Cecilia. So why don't you give the details?
So as you mentioned before, in the U visa context, the work permit can be given once the applicant is put on the U visa wait list. And right now, from today, it's about a 3.5-year wait, even for that first kind of placement on the wait list, not even kind of the issuance of the full 4-year visa. So work authorization at this moment is going to be a very long wait, because you're going to have to wait for that applicant to be on their case to be adjudicated. And so right now, in March 2018, so they're only working on cases that were filed in kind of August, September of 2014, so there is a ways to go. And it's a problem because of the really long processing times. That's a long time to kind of be waiting. So,
and because it's a problem, we had been trying to work with headquarters to come up with a swifter work authorization system, which doesn't look like that's going to help, but we have been exploring ways to get them to implement a section of the law that was added in 2005 that says they may do bona fide work authorization decisions. So if you're interested in that, let us know. It's an email group that's been meeting and basically filing cases in federal court or threatening to file cases in federal court. And I will give you the details offline if you'd like more on that. Okay. Looks like we've run out of gas here. So if we don't see other questions, we'd like to thank all of you very much for joining us. And we hope to get you know personally over the next few years. Please contact us either through the questions or you can contact through our individual emails. And there's a lot of stuff on our website. It's all free. Cecilia's been working hard on making it more accessible, but you'll find a lot of things there that I think that will help you. And thanks to the UTA to TA gals for running this for us and for the captioning folks. We really appreciate your help.